Mr. Ho, you mentioned some jurisdictions where Section 2 cases have taken place since Holder, Shelby v. Holder. Where are those jurisdictions? Are they predominantly in any particular class of jurisdictions?
So there have been 26 successful Section 2 cases since Shelby County versus Holder, and I define successful case as a case where either a court ruled in favor of the plaintiffs or the parties settled and the plaintiffs got some of the relief, some or all of the relief that they sought. I think two things stand out when you look at what kind of jurisdictions those cases arose from. The first is that of those 26 cases, I think 16 of them, and there's a table in my written testimony that sets this out, happened at the local level. So a majority of the successful Section 2 litigation that we've seen happens at the city, county, school board level. And I think what that speaks to is the importance of the notice and transparency requirements of the VRAA, because changes to voting laws at the local level are harder to detect. And that's something that we lost with the demise of the preclearance regime. The second thing is that a majority of these cases arose from a small handful of states, and again, they're set forth in my testimony, that used to be covered by Section 5. And that provides, I think, some evidence that the problem of voting discrimination remains concentrated in particular places and justifies particular congressional attention to those places.
And those states, if I remember correctly, that were in the preclearance area were all in the old Confederacy, but for Arizona, as far as states go. Is that not accurate?
As far as fully covered states go, I believe that's right, but there were some partially covered states, California and New York, that were not.
And they were partially covered. That's because they were local jurisdictions. They happened to be in the state.
That's correct.
Right. And then those were the states where most of this Section 2 action took place.
That's correct.
So the old expression in the song Dixie, "Old times there are not forgotten," maybe has more of a current ring than one would understand.
Well, I think the numbers speak for themselves.
Yes, sir. Ms. Perez, on purges, what are some of the reasons for purges?
There are a lot of reasons for purges. Some of them are necessary. We want our voter rolls to be clean, so people are removing them because people have died, people have moved, people are no longer eligible because of a criminal conviction. The problem that we are seeing in this country is that purges are on the rise. The protections that were once available to let the public and the Department of Justice know about purge practices that had changed are no longer available. And when people are purged, they often find out on Election Day when it's too late.
Are some of the purges because people haven't voted in X amount of elections for a certain period of time?
A number of states have different practices that they use. Every state in the country that is subject to the NVRA has a process by which if someone is flagged for a certain reason for removal, they can be given a notice, and if they don't respond to the notice. Let me go back to my question.
Sure. Do not some jurisdictions purge you because you haven't voted within the last 2 years, 4 years, 6 years, or whatever?
There are some states that have policies like that, yes.
And are those states have any particular similarities? Are they particularly in preclearance states, or are they just willy-nilly?
No, sir. But one of the things that is important about the preclearance provision is that it accounts for changing practices. So a state could change its practice to encapsulate more people in the purge process.
But you said, did you not say that since Shelby versus Holder, purges have increased in preclearance states while they have not increased in other states?
That is correct. That is correct. The states, however, that use a policy like, for example, I'm assuming you're pointing to Ohio's and the like, that use a failure to vote as a trigger for sending a notice, and other ones are in more places just in the southern states.
You're familiar with Australia, where it's required by law that you have to vote.
That is correct.
So how do they get along? Well, they don't have to purge anybody, do they?
I'm actually not familiar with how they enact the law, but what I think is important in this country is that we have a continuing evidence of discrimination, and Congress has vast authority to be able to rectify that pursuant to its authority under the 15th Amendment.
Ms. Gupta, since the effective suspension of Section 5 preclearance, Holder, Shelby, what has been the pace of litigation under Section 2, which we discussed with Mr. Ho, in formerly covered jurisdictions compared to non-covered ones? Have you seen the preclearance states that were in the previous Voting Rights Act be more active and have been found in litigation to have been more active?
Well, private litigants, like my colleagues sitting here at the table, have certainly had to engage in much greater activity in Section 2 litigation. And my colleague Dale Ho, the chart really shows the degree to which there's been a need for Section 2 litigation in jurisdictions that were previously pre-cleared or had a pre-clearance regime with the Justice Department. And I also, I mean, there's been a stark marked contrast now with the Justice Department under the Trump administration, which has not opened a single voting rights investigation. But for the private litigants, the effort now to become aware of hyperlocal changes, which are often very hard to detect at the national level, has become imperative to be able to protect people's right to vote. And it's why we're here today to urge restoration of the Voting Rights Act.
Thank you. Mr. Johnson, you're recognized. Mr. Johnson, you're recognized for 5 minutes.
Thank you, Mr. Chairman.